Okay. You wanted me to remind the jury to disregard those last comments of Mr. Arbenz, and hopefully I'll remember this time. Sorry about that. And there was a motion that Mr. Conrad filed this morning about examination of, I guess, mostly defense experts. And the state wants to delay responding to that till tomorrow morning because they want to respond in writing.
Yes, hopefully we can file it later tonight. If not, we'll file a response tomorrow morning.
That's, I probably won't read it until tomorrow morning in any event. Because once I leave here, I don't have access to my computer where it would be filed. That shouldn't cause any problem for you, Mr. Conrad, right? You're not intending to call anybody that's going to be an issue with respect to that until after that anyway, right?
Correct, Your Honor.
Okay, so we're good. All right. Can we have the deputy back then, and we can have the jury come on in? All right, let's have the jury. Welcome back, everyone. Please be seated. Before we resume this afternoon, there was something I wanted to say to you all before we resumed after the 11 o'clock recess. And that is, there was a comment made by Mr. Arbenz in his closing argument, which I think was the last thing he said to you about being good to Mr. Collins because Mr. Collins has been good to the community. And I want you to disregard that comment. You're to decide this, you're to permit neither sympathy nor prejudice to influence your decisions in this case. You're to decide the case based on the evidence and based on the facts you find have been proved based upon the evidence presented in court and upon the law given to you by the court. And by applying the law to the facts, you decide the case. And that's the basis. So you'll get more instructions about that later on, but just so we're clear. Now, with having no further ado, you can resume your direct examination of Deputy Bol.
Thank you, Your Honor. Can we pull that exhibit back up, please? 2513. And Deputy Wolfe, I want to ask you about a question about the initial part of this video that we hear. And so if we could play the initial part, please. Play that one more time. Thank you. Do you hear that at the beginning of the video?
Yes, sir.
And the noise that, and do you remember who that was coming from?
That was Manuel Ellis, sir.
Okay. And at this point, had Mr. Ellis been tased at all?
Negative.
Okay. And had there been any contact with him between law enforcement and Mr. Ellis?
No, sir.
Okay. And you mentioned the word excited utterances.
Yes, sir.
Is that what you're describing? Is that the type of noise you're describing?
Yes, that's what I was describing with that word.
And you also described in your testimony Mr. Ellis jumping up and running initially at you all, but then stopping about 17 yards or so from you all.
About that.
Did that occur prior to this video recording?
I would say that when I said that he jumped up to run at us, that was the initial push up and scramble that he did. And it's shortly into this video. That was the first one that I was talking about.
Okay. And then afterwards, when we see him jump up and run towards you, that's the second one that you're describing?
Yes, sir.
Okay. And you wrote a report in this case, is that right?
Yes, I did.
What date did you author that report?
Can I look at my paperwork here? I reported it on September 21st, that evening.
September 21st, 2019
Yes, sir.
is when you wrote the report.
Yes, sir.
Okay. I don't have any further questions. Thanks, sir.
Thank you, sir.
Ms. Nicolavo?
Good afternoon, Deputy Wolfe.
Afternoon, ma'am.
You have Exhibit 2511 up there with you,
Yes, I do.
and that's the .2 report that you just testified about that you wrote the night of the incident.
Yes, ma'am.
Would you agree with me that the importance of writing a report is to document significant facts
Yes, ma'am.
and to also document any significant observations you made that night?
Yes, ma'am.
It's also used to document if there's any force used
Yes, ma'am.
and the nature of that force
Yes, ma'am.
and the reason for that force.
Yes, ma'am.
And your narrative, the portion of your report that you wrote out what happened, is actually 2 paragraphs, right?
Yes, ma'am.
And in those 2 paragraphs, you testified to us today that Mr. Ellis's eyes were huge. They were wide-eyed. Remember that testimony?
Yes, ma'am.
You didn't include that in your report, did you?
Let me look. No, ma'am, I didn't make a comment on his eyes in the report.
You also testified today that when you saw him with the street lamps on him, you could see the mixture of blood and sweat. Remember that testimony?
Yes, ma'am.
You didn't document that in your report, did you?
Believe I did, ma'am.
The sweat? Can you tell me where?
Oh, no, ma'am. I was mistaken. I said covered in blood from a severe head wound.
Okay. Nothing about sweating profusely or anything of that nature?
Not in my report, no, ma'am.
And you testified just a few minutes ago about what you called excited utterances and what you testified to before lunch you called grunting noises.
Yes, ma'am.
You didn't include that in your report.
No, ma'am.
You also testified that before lunch that you were certain he was under the influence of a controlled substance. Do you remember that?
Yes, ma'am.
And you didn't include that in your report.
Let me look at it one more time. No, it doesn't look like I did, ma'am.
And you were interviewed by defense back in December of 2022, correct?
I believe so, ma'am.
And no one from the prosecuting attorney's office or EGO's office was present for that.
No, I was never contacted by you guys at all.
And you didn't give any notice to anyone that you, from the state, that you were going to be giving an interview to defense?
Sustained.
And that interview then in December of 2022, that was about 27 months after the September 2019 incident, is that right?
I'm not good at math, but I would assume long time.
It reads at least 2 years past.
Oh, yes, ma'am.
And the facts that you testified to today that I just asked you about, none of those were included in the report?
No, ma'am.
On the 2019 incident, September of 2019, at any time during that interaction, none of the deputies that responded had to punch Mr. Ellis in the face.
What was that, you said December?
September.
September, yeah,
If
go
I
ahead.
misspoke, I apologize.
Yeah, I just want to be clear, I thought you said December, but
No,
maybe I
thank you.
misheard it.
Thank you. September of 2019, none of the deputies that responded had to punch Mr. Ellis repeatedly in the face to get control of him.
Sustained.
There was never a hobble that was placed on Mr. Ellis.
We didn't need one. We were using our body weight, and the fire department showed up very quickly.
And so he was never put in a 4-point restraint.
Not to my remembrance, ma'am. No.
And you didn't put a spit hood on him.
No.
Sustained.
In the time in which you interacted with Mr. Ellis in September of 2019, he never told you that you couldn't breathe?
Sustained.
Did you ever see him exhibit signs of air hunger in the time that you had him under arrest?
Air hunger, ma'am?
Did he ever exhibit signs that he was struggling to breathe in the time that you had him under arrest?
From my recollection, he was panting, seemed exhausted, but I wasn't monitoring him on a medical level.
Did he ever express to you that he was having difficulty gaining his breath?
He wasn't making very clear sentences when he was down on the ground, ma'am.
He was able to tell you that his name.
From when I had him proned out, yes, he told me his name, but he wasn't making clear sentences when we had him in custody, ma'am.
And he responded to the call of your question then?
He responded to the call my question. What do you mean, ma'am?
You asked him his name and it made sense in the response that he provided you,
Oh,
correct?
yes, ma'am.
There wasn't any issue with him understanding what you were asking based on his answer?
No, ma'am, but then also when I told him to stay on the ground, he didn't listen to that.
And he initially complied with you, correct?
Yes, ma'am.
No further questions at this time,
Yes, thank you, Deputy. Good afternoon.
Deputy, sir.
The video that you testified about, you did not, or you were not aware that the video was taken of that evening, correct?
No, sir.
And so you testified regarding your observations of the events that occurred that evening, correct?
Yes, sir.
And then you saw the video how long after that particular point in time?
Months, I would say 4 months.
Okay. And in the video, you initially told Mr. Ellis, before you knew his name actually, to get on the ground, correct?
Yes, sir.
And he's naked at this point in time.
Yes, sir.
Right. And so he gets on the ground and he makes some grunt noises, correct?
Yes, sir.
And then you said, stay on the ground.
Yes, sir.
He didn't stay on the ground, did he?
No.
All right, so he got up and he started to come after you.
Yes, sir.
Right. Now, when you were there, you said your firearm was at low ready at that point in time?
Yes, sir.
Did it ever train on Mr. Ellis at that point when he started to get back up off the ground?
It was getting higher, so that, yes, sir.
And then also, I think you said that Officer Bol was present as well.
Yes, sir.
He was on the passenger side of the car, or the other side of the car from where you were at?
I was on the passenger side. He was to my right shoulder.
So he was on the passenger side as well?
Yes, sir.
Okay. And was there any other officer present at that point in time?
Other than Deputy Hoisington being on the driver's side of the vehicle.
And did you know where Deputy Poisonton's weapon was trained?
I know that he didn't have it drawn because he was actively putting on gloves.
Okay. And then you saw, as we all saw, Mr. Ellis was down on the ground,
Yes, sir.
correct? And then he got up and he charged both you and Officer Bol,
Yes, sir.
correct? How far away from you was he before Officer Bol hit him with a taser?
I would say 5 feet at the max.
Was your gun up at the firing position at that point in time?
Yes, sir.
Were you ready to fire at him?
Yes, sir.
He was attacking both you and Officer Bol.
Yes, sir.
That's not in the report either, was it?
Native, sir.
That's all I have.
Mr. Edmonds?
Deputy, just one question. Ms. Nicolavo asked you about whether you wrote in your report that Mr. Ellis had wide eyes, I think as you described them.
Yes, sir.
You recall that? Do you have an independent recollection of his eyes that night?
Yes, sir.
Is that because you almost shot him?
Yes, sir.
Doesn't matter. Thank you.
Briefly, Deputy, how many times have you encountered an individual running naked down Pacific Avenue? Goes to his independent recollection of this.
Sustained.
Okay.
New question.
You wrote a report in this case, correct?
Yes, sir.
Do you have an independent recollection of this incident?
Yes, I do, sir.
Why?
It hangs in my memory as a large call that I've had to respond to.
Okay. I don't have any other questions.
Just a few questions, follow up on that.
Go right ahead.
Mr. Kurtzer asked you questions about, you had your firearm in the low and ready, that's the sole position?
No, ma'am.
No?
Sewell is pointing down your body line. I had mine right about here so that I could bring it up.
That's how you started out at the beginning of the call?
Yes.
Okay. And you had, at the time that you brought it up out in front of you, you had 3 other officers there, 3 other deputies there?
Just myself, Deputy Hoisington, and Deputy Bol.
So 3 including yourself.
Yes, ma'am.
And Mr. Ellis was standing in the roadway, goes down, stands up. You knew he was naked, right?
Yes, ma'am.
And you knew he didn't have any weapon on him, considering he was naked, right?
Yes, ma'am.
And he never struck you,
Not yet.
and he never punched you,
Not yet, ma'am.
and didn't do anything physically to assault you.
Not yet, ma'am.
And you were ready to pull the trigger.
Yes, ma'am.
Thank you.
Okay, Deputy, thank you very much. You're excused.
Thank you.
Next witness.
Deputy Bol. The outside.
Go get it.
Walking up the stairs like.
Okay. Yes, sir, please come forward to right about here, and then raise your right hand to be sworn. Solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you very much, sir. Have a seat right there. Please state your name and please spell your name.
Sorry, I ran the stairs. I'm a little winded. My name's Gabriel Bol, Gabriel Bol.
You okay?
Sure. Tie's a little tight.
Whenever you're ready.
Deputy, can you tell us what your occupation is?
Yes, I'm a deputy with the Pierce County Sheriff's Department.
Okay. How long have you been a deputy for?
Just over 6 years.
Any professions prior to that?
I was with the Washington State Patrol for 3 years.
Okay. And I want to ask you about September 21st, 2019, a call that you were dispatched to. Do you remember that evening?
Yes.
Okay. And what can you tell us about the call that you were dispatched to?
I was dispatched to an armed robbery at the A&W near the 14500 block of Pacific Avenue South. Prior to my arrival, the suspect had fled on foot. While I was still en route, I learned that Deputy Wolfe and Deputy Hoisington were contacting the suspect near the 13600 block of Pacific Avenue South. I responded with them to that location, or after them rather. They had the suspect proned out. He was laying down in the roadway in lane 1 northbound on Pacific Avenue. They had him at gunpoint. I exited my patrol vehicle, drew my department-issued firearm, and went to Deputy Wolfe's side, the roadway side, because I from my perspective, I had the best vantage point from the passenger side of their vehicle. Since there was lethal cover, Deputy Wolfe had his firearm drawn. I decided to holster my firearm and unholster my taser. We were given the suspect commands to stay on the ground, keep his hands out, stay on the ground, and he didn't comply. He charged at us, and I tased him. The first taser application appeared to work, appeared to have an effect, but it very quickly dissipated. So I administered another taser application. Both of them are 5 seconds each. During that second taser application, we were able to take him into custody. I didn't apply the handcuffs. I was operating the taser at the time, but other deputies on scene were able to put him in handcuffs.
Okay. And I want to kind of unpack that a little bit. What kind of commands were you giving to him when he was in front of the vehicle?
I just recall telling him to stay on the ground.
Okay. And what was his demeanor like?
I remember he was very fidgety, moving around a lot. He kept looking around, kind of posturing almost in a push-up position, trying to get up. That's why we told him to stay down, stay on the ground. And he did not.
Okay. Do you remember if he said anything or?
Not that I recall, no.
Okay. And is it unusual for him to run at you as opposed to away from
Objection,
you?
Your Honor.
Overruled, you may answer.
I'm sorry, what's the question?
So the question is, I'm wondering if it's unusual in your experience for an individual like that to run at you as opposed to away from you.
Same objection.
Same ruling. You may answer.
Well, I would say that it's unusual for people to run directly at us, yes.
Okay. And you said that you administered a first taser application that took 5 seconds. It's a 5-second cycle, is that right?
That's correct.
And I mean, how does that work when the 5-second cycle ends? Is it unusual for an individual then to just regain strength right away?
You could ask him about his experience, I guess, with taser applications.
Have you had to use your taser previous to this incident?
Yes.
Okay. And was there anything unique about the use of your taser during this incident as opposed to others?
Unique as far as the operability, or?
Unique in terms of the individual's reaction to it?
Yes, I've been tased personally, part of the training, and it's exhausting.
Okay. Just from one application?
Correct.
And in this instance, you indicated that after the first application that what was his reaction after the first application?
From recollection, it doesn't exactly match my report, but from recollection, he basically bounced off the ground. His recovery was very quick, almost immediate, and continued charging at us.
Okay. And it sounds like you were eventually able to detain him in handcuffs, is that right?
Correct.
And while you waited for, was there a call for medical aid as well?
Yes.
Okay. And what was Mr. Ellis's behavior while you waited for medical?
He was breathing heavy. He was still, looking around, still very hypervigilant, still like squirming. Even though he was in handcuffs, he didn't have his hands to push up off the ground, but he was still moving around. And it took at least 2 deputies that I recall holding him in place so he doesn't hurt himself or hurt anyone else.
What do you mean by hypervigilant?
Just, darting around, like looking around.
Okay. And did you ever ask him any questions?
Yes.
What did you ask him?
I asked him what his name was, and I asked him if he was on any drugs.
And what was his response?
He told me he was on meth and weed.
happened after fire round? You need to refer to your report, let me know.
Yeah, I read my report several times.
Okay.
Absolutely. He was assisted onto a gurney, not by myself, but I do believe by fire personnel, and then transported to the hospital.
And were you there during the time that he was at the hospital?
Yes.
Was there anything that occurred at the hospital while you were there?
I don't have any independent recollection, but I did, again, review my report. And at the hospital, I advised him of his Miranda warnings.
At this point, the state had made an objection to this earlier, the court was going to rescind your ruling, and I just didn't know what the court's verdict was on those statements.
Well, can I see your report?
Yes, sir.
All right.
I printed two sides, so it's the bottom of this one and then that.
Thanks.
There's nothing else.
Right. Based on the prior motion, this is, I'm not going to exclude this. Is there any other objection?
No, Your Honor, I just wanted a ruling on that before we went forward, thank you.
Okay.
So you're talking about being at the hospital with Mr. Ellis. What were your interactions like with him at the hospital?
If I may review my report for that.
Go ahead.
Okay.
And what were your interactions like?
I advised him of his Miranda warnings off of a pre-printed card. He said he understood. Then I asked him if he knew about the events of the evening, and he said he doesn't remember. And then I had reminded him that he was at the A&W, and that's when he told me he was in a fight, and then he ended up at the hospital.
Okay. And did you transport Mr. Ellis somewhere after the hospital?
Yes.
Objection, Your Honor, relevance?
Answer stands.
And where did you transfer him to?
After he was released from the hospital, I transported him to the Pierce County Jail.
And what hospital did he go to?
I don't recall, if I can review my report.
Please.
My report reflects that he was taken to the Good Samaritan Hospital.
Sorry, can you say that again?
Good Samaritan Hospital?
Okay. And what charge was Mr. Ellis booked in on?
Objection, Your Honor, relevance?
Sustained.
You wrote a report in this case, Deputy, is that right?
Yes.
And what date did you author that report?
On the date of the incident, September 21st, 2019.
Okay. And your report is part of a number of reports that are written in this case, is that right?
Yes.
Are there other officers that also wrote reports?
Yes.
Okay. And I don't believe I have any further questions. Thank you, Deputy.
Okay.
After afternoon, Deputy.
Hello.
Finch just asked you a couple questions about your report and the reports of other officers. When you write that report, the importance of doing so is to document your own memory of the events, right?
Correct.
And your own observations.
Correct.
And although read as a whole with the other officers that responded, the purpose of your report is your recollection.
Correct.
And it's also to document anything that's significant.
Correct.
All right. You just testified that you tased Mr. Ellis twice, correct?
Yes.
And you said that he charged after the first taser, so you tased him again.
Yes.
But you did not include in your report that he charged you a second time.
I'm sorry.
You did not include in your report that he charged you prior to the second deployment.
I'm completely confused.
It's okay, maybe I'm not phrasing the question well enough. In your report, you documented that you tased him the first time, right?
Correct.
And you also documented that you tased him a second time, right?
Correct.
And nowhere in your report do you document that the reason for tasing him the second time is because he charged you again.
I could read from my report if you'd like.
Why don't you tell me what paragraph it's in where you indicate that he charged in between those two tasers?
Yes. This is the report form from Enforcer, the report form that we have. That I printed it off. So the third paragraph in that, it says, at that moment, he rapidly sprung up and charged right at us. I called out, taser, taser, and I fired the probes into his torso. He immediately fell to the ground, but just as quickly as he fell, he was getting back up to continue his charge. Since the first application appeared to have an effect, I decided to administer another application. During the neuromuscular incapacitation of the second application, he was detained in handcuffs.
So, Deputy, the first taser, you talked that he charged you, right? That you just read off. He charged you and then you tased him the first time, right?
Yes.
And the second time, he is getting up. Hasn't charged you a second time, has he?
From my perspective, he was continuing to advance on us.
And have you watched the video of this incident?
Yes.
And all of the tasing occurs behind the vehicle, correct?
Yes.
And it all occurs within 10 seconds?
I'm not exactly sure.
You tase him once, it's 5 seconds,
Yes.
and you almost immediately tase him again?
Yes.
And you also called out to him, taser, taser, because that's part of what the training is, right?
Correct.
And you give him a warning every time you're gonna call out taser, taser, right?
Correct.
And that's the proper procedure when you're tasing someone?
Yes.
And why is that?
Which part?
Why do you call out taser, taser?
So other officers there with lethal cover don't think that the firearm was fired.
And you also call it out to advise the person that you're tasing of what's gonna happen, right?
Correct.
It's a warning to that person.
Yes.
And that's across the board, common training for using a taser.
I'll allow this overruled.
What was your question?
It's across the board for law enforcement training is to yell taser, taser right before you do it.
To my understanding, yes.
I'm sorry, could you please repeat your answer?
Yes.
And you also testified today that Mr. Ellis was hypervigilant, right?
Yes.
Did you include that anywhere in your report?
I don't believe so.
And you said that medics were called almost immediately, right?
Yes.
And they were called priority immediately, right?
Yes.
And during your interaction with Mr. Ellis, he never indicated to you that he was struggling to breathe?
Not that I recall.
And he never never showed any signs or manifested any signs of being air hungry?
Not that I recall.
And he didn't die when he was on your watch and in your care and custody control?
Sustained counsel.
You testified that you asked him several questions, right, when you were at the hospital?
Yes.
And you continued to ask him questions, and you documented in your report that Mr. Ellis was going in and out of consciousness during the time that you were talking to him.
Yes.
And that was his status when you were asking him the questions that you just testified to with defense. Is that correct?
At what time?
At the hospital?
Yes, at the hospital.
Nothing further, thank you.
You already think I don't have any questions.
Ms. Strasser?
Good afternoon, how are you, Deputy Bol?
Hi.
Do you have an independent recollection about the incident we're talking about with Mr. Ellis?
Yes.
Stick in your mind.
Yes.
Is it because of the nature of how it unfolded
Yes.
and the fear probably that you exhibited?
Objection, Your Honor.
Sustained.
Sorry, Judge, this is cross-examination.
You can lead to some extent, not to this extent.
All right. So is it fair, do you have an independent recollection of things that are not included in your report?
Yes.
Okay. And so are you testifying from memory to those?
Yes.
Points? All right. Ms. Nicolava asked you about whether Mr. Ellis was air hungry. Do you know how much meth he was on that night?
No.
Do you know when he last consumed meth before you contacted him?
No.
Did you know anything about his drug usage that day?
No.
All right. If I understand, Deputy Wolfe and Hoisington are on scene before you get there?
Yes.
Okay. And then some other officers arrived, right?
Yes.
Do you know who those officers were?
From memory, I only know two.
Okay. Who were those two?
One of them was Deputy Davenport, or Deputy Lampton, and the other one was Deputy Oni.
Oni?
Yep, correct.
When you say Davenport, did Davenport's name change to?
No, he has a two-part last name.
Oh, okay. So when you say Davenport in your report, you're referring to the same?
Deputy Lampton is the same person, yes, sir.
Okay. All right. And Ms. Nicolava asked you about the failure to include that Mr. Ellis charged at you on multiple occasions. You actually include that in your report, right?
Yes, I believe that that's what I was indicating in my report.
All right, third paragraph, right?
Yes.
While you're waiting for medics to arrive, other officers had to physically restrain Mr. Ellis, right?
Correct.
In fact, they had to apply downward pressure as he was in a prone position with cuffs, right?
Yes.
To keep him from getting back up.
Objection, Your Honor, leading.
Sustained.
Why were they doing that?
Because he was trying to get up, and our thought was he was maybe going to continue to be assaultive.
How long did officers have to restrain with downward pressure in the prone position until medics got there?
I'm sorry, the question was the time frame?
Duration.
I'm not exactly sure, but it wasn't very long.
Okay. Was that done the entire time you waited for medics to arrive?
To my knowledge, yes.
Okay. Deputy Wolfe testified this morning, a little bit earlier, and reported that Mr. Ellis tried to stand up while he was on his back. Did you see that?
Not that I recall.
Okay. You don't have a recollection of that?
No.
Okay, thank you. Thank you, Judge, that's all I have.
No regret, Your Honor.
Recross in the state?
Nothing from the state, Your Honor, thank you.
Nothing more, please.
Okay. Deputy, you're excused. Thank you.
Thank you, sir.
There is a step down.
Okay, next witness.
Your Honor, may I inquire as to who the next witness is? If it's Mr. Greer, there is a matter to be taken outside the presidential.
It's Mr. Pollock.
Thank you.
Okay, so the next witness is who?
Cody, Pollock.
Oh, okay. Yes, sir. Please come forward to right about here, and then raise your right hand to be sworn. Solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much, sir. Have a seat right here. Please state your name and please spell your name.
My name is Cody Pollock. That's Cody Pollock.
Thank you. Mr. Conrad.
Good afternoon, Mr. Pollock. Just want to get some background information briefly on you. What do you currently do for occupation?
I'm currently a marketing coordinator / handyman.
Okay. And how long have you been doing that?
3 years now.
And what was your job prior to that?
Before that, I was with Nash Power Sports, and before that, I was with Larson Power Sports.
Okay. What about previous to that?
Then I was with Multicare at Good Samaritan Hospital in Puyallup
Okay. And how long did you work at the Multicare Good Samaritan Hospital?
for 3 years.
And what was your job title there?
Emergency room tech / charge tech.
Okay. And what's an emergency room tech / charge tech?
It's going to be an EMT in the emergency room. We are going to be the doctor's right-hand man. If they're doing a procedure, we're in there helping them. Or if there's a nurse in there doing a procedure, again, we're in there helping them.
Okay. And any certification or training required for that position?
The EMT basic is something I had before that, but we are provide training on the job for different situations and phlebotomy training and basic patient care training also.
Okay. And I want to ask you about September 21st, 2019, a visit that you were involved in. Did you happen to take care of a patient by the name of Manuel Ellis on September 21st, 2019?
After referring to the notes I was provided, yes, I did.
Okay. And what notes did you review?
I reviewed the chart with my written note inside of it.
Okay. And the chart notes, those are the multi-care medical records?
Correct.
Okay. And I'm going to show you what the marked as Plaintiff's Exhibit 981.
If you could. Of course.
Did you say 981?
Yes, Your Honor.
Thanks. Ms. Flagger, let us know when you're ready.
Good to go? All right. Let me know if you have to stop. Can you take a moment to review Exhibit 981?
Okay.
I just want to ask you if those are the medical records that you had reviewed prior to your testimony.
Yes, it is.
Okay. And let me ask you, in the course of your duties, do you routinely take notes and document that information?
Yes, I do. Every note I put in there is because of a patient interaction. I'm trying to document every patient interaction I have to keep a record of it.
And why do you do
To keep a true medical record for what's going on with the patient.
that? And is that important in terms of providing care to patients?
Yes, it is very important.
Why is it?
If anything happens after the fact, or it's also good communication for the doctors and nurses if I can't talk directly with them, or his providing health partner or healthcare provider later on to review too.
Okay. And what kind of information do you typically include within the medical record?
I'll include normally my patient interaction I had, or if anything stood out to me, or if the patient has said or done anything to me.
And do you rely upon the medical notes or chart notes that are contained in a patient's file that are not your own?
Yes, I do, because that's also a good way for a doctor to give me orders. I can review it that way, so I can see that the doctor's asked me to do something.
Okay. So I want to ask you about the treatment of Mr. Ellis. What was your involvement in the treatment of Mr. Ellis on September 21st, 2019?
After reviewing the chart, I believe I was the tech that was assigned to his area where he was a patient at. And I do believe after reviewing everything, I helped get him settled in the room by taking vitals and then eventually ended up cleaning out his wounds for him.
Okay. And based on your review of those records, does it indicate to you whether any medication was administered to Mr. Ellis?
Yes, per my note and reading the notes from other providers, it looks like there was Adavan that was given to him twice, along with looks like some saline, which would just be an IV.
Okay. And how about lidocaine?
Yes, lidocaine is there too, and that's used to numb up the wounds.
And did it indicate within those medical records when Adavan had been given to Mr. Ellis?
It did. There's 2 time slots. I'd have to review it to see when it was actually given.
Sure, go ahead. I think if you look at the bottom of the page, it says 3817.
You said 3817.
Uh-huh.
So I have these numbers.
Oh, sorry. If you look on 3817 here.
Oh, okay. Yep.
Does it indicate whether, at what times Adavan had been provided?
Yes, it looks like it was given at 9:58 p.m. and 10:27 p.m.
Okay. And so were one of those doses given prior to you administering or cleaning out the wound?
Yes, it appears that after reviewing my note, yes.
Okay. And what's the purpose of giving a patient Adavan?
To do either a medical restraint or to calm them down.
Okay. And so take me through what your process is when you're cleaning out a patient's wound.
When I'm cleaning out a patient's wound, I first introduce myself and explain what I'm doing. I always ask the patient for permission to treat them, because if I can't get permission from them, then it's considered assault and battery. So I always explain to what I'm doing, what I'm going to be doing, and ask them for permission. And then after that, I start cleaning the wound out. I believe with the wounds that I was presented, it said I use a lot of saline to flush them out. And saline's normally my go-to for a flush.
And based on your note, was there anything that occurred between you and Mr. Ellis while you were treating him?
Yes, refer back to my note again, because it's 3 years ago. Sounds like he sat up, postured at me, and clenched his fist at me.
Okay. And you took a specific chart note regarding this?
Yes, I did.
And if you could turn to page 3862. Does that page include your chart note?
Yes, it does.
And are these records kept in the normal course of business with multi-care?
Yes, they are.
And you made that chart note at or near the time that this event occurred, is that right?
I did it as a late entry, so that means that I would have done it after the fact. If this would have happened at a certain time and I didn't have time right away to write a note, whether an emergency came in or not, I did it as a late entry, since it wasn't at the exact time that it happened.
And could you read for the jury what the chart note says?
Absolutely. It says, late entry, while cleaning out patient's wound, patient woke up and aggressively postured at this tech, with fists clenched. This tech was able to talk patient down while Pierce County Sheriff entered the room. This tech explained the process to the patient and the procedure of me cleaning out his wounds and what was required of the patient. RN was consulted and additional meds were ordered. Patient was more calm with this tech while cleaning out the wounds.
Okay. And when you indicate that you explained the process to him, is that something that you had done, you typically do at the forefront as well?
Absolutely.
Okay. So you're indicating that you did that again?
Yes, I did.
And that note indicates that there was additional meds ordered, is that right?
Yes, according to that note, yes.
And what were those additional meds that were ordered?
I believe after looking at the chart, it was another dose of Adavan.
And why was another dose of Adavan?
I believe because he got aggressive with me, and that was another way to calm him down so we can treat him properly.
And is it unusual for someone within this emergency room department for someone to become combative or aggressive with you?
It is,
Governor objects to its relevance.
Sustain. Sustain.
Why would you include a note to this?
because that stood out to me. I can, in the ER, I can be cussed at and people can be very aggressive towards me, but that's just a day in the ER for me. This note stood out because I actually wrote it because it was a step up from the normal aggressiveness.
I don't have any further questions, thank you.
Good afternoon, Mr. Pollock.
Hello.
We haven't met before.
No.
But my name is Patty Deeks, and I'm one of the prosecutors in the case. So I just want to follow up and ask you some questions here. So first of all, on the notes that you were looking at, your entry on Bates number 3862. Can you take a look at the prior page, 3861?
Yes,
And you see that those are notes that are entered by the nurse, is that correct?
that is two different nurses, yes.
Okay. And one of the notes is at 2204, correct?
Correct.
And that's actually a note prior to your incident with Mr. Ellis, correct?
I do not know.
Okay. Well, if you take a look at the next entry at 2230, that's another entry by Miss Morris, correct?
Correct, yes.
And you see there that she makes a reference to the incident that you wrote the late note about, correct?
Correct, yes.
All right. So the 2204 note would have been before your interaction with Mr. Ellis, correct?
Before my no interaction, yes, but I would have had an interaction to receive the patient and to set up vitals, that kind of stuff.
Okay. But before the incident that you're talking about where you startled him awake, correct?
I don't believe I said I startled him awake.
Okay, I'm sorry. Didn't you read that he was awake? You woke him up. While you were cleaning out the wounds, patient woke up, correct?
Correct, yes.
So Mr. Ellis was asleep when you were taking care of his wounds, correct?
Yes, you could assume that.
Okay, so he wasn't, you hadn't had a conversation with him, hey, I'm gonna do this, and then he suddenly got upset. He was actually sleeping when you started cleaning out his wounds, correct?
I would have had a conversation with him before that, explaining the process, because I had to get his permission to treat him. He could have fallen asleep then, and then I could have cleaned out his wounds.
Okay, but when this interaction happened, he had been asleep, is that right?
Correct.
All right. So if you look at the prior note at 2204, you see that the nurse indicated that Mr. Ellis was cooperative and easily redirectable, correct?
Yes.
All right. And now you talked about the Adavan. In fact, Mr. Ellis was given the Adavan, was he not, in order to facilitate the scans that he had done? A CT scan, right?
I do not know that, no.
All right, why don't you take a look at the page, that's the Bates number is 4022.
You said 4022?
Yes.
Mine only goes to 3931.
All right, let me have you take a look then at Exhibit 982. I hand you this whole notebook.
Okay.
All right, this is Exhibit 982, and if you could take a look at the Bates page, page that's numbered, it ends, that's 4022, please. 4022.
I am there.
All right. And you see at the bottom of page 4022, it indicates that Mr. Ellis was given Adavan in order to lie still for the CTs. Do you see that?
Yes, I do see that.
Now, going back to 981, first of all, when Mr. Ellis came in, he had a multitude of injuries, did he not?
Referring to my note, yes, he did.
Okay. And he had lacerations to his head,
Yes.
and he had, that required some stitching, is that right?
Yes.
And he had to have multiple scans done at the hospital, is that right?
According to the record, yes.
Even in addition to the CT scan we talked about, he had 3 other scans, is that right?
I believe so. That's what's in the record, yes.
And he had a large hematoma to the back of his head, is that right?
According to the record again, yes.
And that's a large bruise, basically a collection of blood in the back of his head.
Yes.
And he also had an injury to his right lateral eyebrow,
According to the records, yes.
and also an injury to his left forehead,
According to the records, yes.
and to his left lateral eyebrow.
According to the records, yes.
And then he had to have his lips sutured, is that right?
According to the records, yes.
And so Mr. Ellis had, all of those wounds were all sutured, is that right?
Yes.
And did you clean out all 4 of those?
Yes, I would have.
All right, now you testified about what time the Adavan was given. If you could take a look at the document, and this is on 982. If you could take a look at the Bates that ends 4055. It also says page 115 on it to the left. Do you have that page?
Yes, I do.
And doesn't that page indicate that the first lorazepam, which is Adavan, was given at 21:15? Is that right?
According to the records, yes.
And
There's
this-
actually 2 times on here of 21:15 and 21:58. I do not know the difference between those 2.
Okay. And you don't know which one was actually, what it means in terms of which time was actually administered?
Correct.
And the records actually indicate he only received 2 doses, correct?
According to the records, yes.
And the second one shows that it was given at 22:25, is that right?
Again, that has 2 times of 22:25 and 22:27.
Okay. And you don't know which one, what either one reflects?
No, I do not.
All right. So if you could go back to 981. Just want to ask you about the note from Nurse Morris.
What's the page on the side? 'Cause I have.
Bates is 3861. Nurse Morris indicates that when she went in, and she came in when Mr. Ellis woke up, when you said he kind of sat up in bed, correct?
I believe so, yes.
All right, and she indicates that he appeared anxious and fearful, is that right?
Yes.
And she said that she explained the procedure, right?
Yes.
And that the patient continued to be anxious, is that right?
Yes.
And that the doctor was notified, correct?
Correct.
Now, you said you had multiple interactions with Mr. Ellis that day?
I believe I would have in the normal course of my job. I only have 1 note in there at the time, though.
Okay. And is that because the other interactions with him presumably didn't warrant any sort of note?
Correct.
All right, but you would have been the tech, you're saying, who would have taken care of all of those stitches and injuries that Mr. Ellis had to have treated, is that correct?
Yes, I would have.
And I take it you don't have any other memory of any other interactions with Mr. Ellis?
No, I do not.
Right there, just a moment. Thank you, Mr. Pollock. I don't have any other questions.
Mr. Bircher?
Thank you, Judge. I don't have any questions.
No question.
Mr. Conrad? Redirect?
In your experience, is it typical for an individual to get lorazepam prior to a CT scan?
No, it is not.
And do the records indicate whether Mr. Ellis was under any type of substance?
I do believe after reading the reports, it was either he said it to us or fire department told us, because he admitted it to the fire department in their report.
And what did he say?
I gotta find that page real quick. Actually, on page 3861, under nurse notes Andre Leonov, it says it endorses ETOH and meth use today.
ETOH?
Yes, alcohol.
Okay. And if you look at, on the Bates label, I have 3813. Are you looking at exhibit?
181, 981,
Okay.
3813.
3813, please. Does that include the fire department's care report?
Yes, it does.
And if I could direct your attention to one of the last sentences there,
Okay.
and what did fire indicate about any substance use?
Per fire's narrative, it says patient admits to using methamphetamine a couple hours ago.
And then one last question I have for you is regarding the doctor's discharge note. And that is page 3907.
Okay.
And what is the discharge note there?
You want me to read the whole note?
Please.
Okay. Manuel, you have multiple lacerations sutured. You will need the lip suture out in 3 to 5 days. You will need the others, right lateral eyebrow, left forehead, left lateral eyebrow, and right back of your head, out in about a week. You had a significant head trauma and might have some concussion type symptoms following. Please follow up with primary care within a week or follow up and further care. Drink plenty of fluids to help improve your kidney function. Follow up for repeat labs within 1 week, and then stop using meth.
And the stop using meth, how does the doctor indicate that within the discharge?
That is in all caps in bold.
Maybe just a couple of additional questions. First of all, Mr. Pollock, you don't actually prescribe any medications, right?
Negative, I do not.
Okay, and so you wouldn't have been the one making decisions about why Mr. Ellis might need particular medications for you?
No, I would not have.
All right. And if you could turn back on Exhibit 981 to the Pierce County Fire and Rescue. Does
What-
that indicate
What page was that again?
981? I'm sorry, it's Exhibit 981, 3813.
Okay.
And does that also indicate in the last line that Mr. Ellis was cooperative during the transport?
Your Honor, you have to be on the scope of the correct.
I just raised that.
This is on the same page that was just asked about, so overruled. You may answer.
I can read it from the note if you'd like.
Does it indicate that he was cooperative during the transport?
It does read that, yes.
And if you could go back to the notes you were looking at, that you were just asked questions about with respect to page 3861.
I am there.
Nurse Morris's note about Mr. Ellis being anxious and fearful, that was at 2230, is that correct?
Yes, that appears that.
Okay, just in a moment. That's all I have, thank you.
Okay. Ms. Pollock, you are excused. Thank you very much.
Thank you.
We're
I leave
now
all
at our
this here?
time. I'm sorry?
I leave all this here?
You can leave all that
Okay.
there. And we're now at time for our afternoon recess, so we'll take our break at this time, ladies and gentlemen. For 15 minutes, please do not discuss the case among yourselves or with anyone else. Thank you very much. Mr. Liu and Mr. Oster, have you guys sorted out whatever your differences are about Mr. Greer?
Yeah, I think we're on the same page, Judge.
I think so.
One clarification. So I intended, Mr. Greer's present somewhere.
I see him. Mhm.
I think it's moot at this point. I mean, we've told the jury multiple times he's charged with robbery in the second degree. Does the court still want me to indicate that he's charged with a serious offense as opposed to robbery in the second degree at this point? I just want Mr. Greer to
Well-
understand what I'm gonna ask him.
Yeah, there was this issue of serious violent offense. Someone used that expression at one point, and there was an objection, because under state law, second-degree robbery is not a serious violent offense. It is a unique statutory, and it falls in the category of violent offenses, I believe. So, calling it a serious felony,
You want me to refer to it as Judge?
well, you say it's a felony. You can say, I suppose, that you can even say it's a violent offense, I suppose, because that's what it is under Washington state law by definition, but I don't know why you'd need to call it a violent offense. I mean, it's kind of self-explanatory, right? Mr. Liu, you got an opinion about any of this?
Well, there's some confusion whether it's attempted robbery, second degree, or robbery second.
Who's charged with robbery?
I think calling it a felony is sufficient.
That's fine. It doesn't matter much. I just want to make sure we comply with the
And so you're saying what, Mr. Liu?
Felony.
Okay.
Is there a reason we can't call it robbery in the second degree at this point, Judge?
No, not at this point, I don't think. 'Cause the only problem is that as I understand it, and I haven't seen the charging document, so again, it's not my issue, but what counsel has advised me is that he was charged with robbery in the second degree, but that the declaration for determination of probable cause actually claims it's attempted robbery in the second degree. And let me see here.
And I can tell that when I spoke to Mr. Greer yesterday, I think his intent was to charge attempted robbery in the second degree.
Right.
And the way it works, Judge, we just put in a code, and you probably put in the wrong code, and it came out robbery as opposed to attempted robbery.
Right. So, was there an amendment of the information at the time of the arraignment or anything? No one picked up on the difference? Are you actually going to admit 2514, which is the information?
That was just for dates.
And now it's to 2515, you're not going to admit that either? Well, then I would say, not to compound the error, attempted robbery in the second degree should be the descriptor.
That's fine.
Okay? And we'll just call it that.
Thank you, Judge.
And then you may get to the release conditions, that document may want to get admitted.
Well,
But
the reason I asked that is the release conditions have the charges as robbery in the second degree on them. So,
of course they do, because those were the charges officially.
and I intend to admit those because there's an objection to Mr. Greer testifying to the condition of release, so.
So we're going to have this problem that on that document it says,
Doesn't accurately reflect the charges, so I would,
well, the thing is technically it did accurately reflect it. It's just that the charge was not properly filed, well, properly described.
and I would propose that we redact that portion on the condition of release.
I don't have an issue with that, Judge, if you want to admit them subject to redaction, and because the ones I have don't have a redaction, we can take that off there, I don't care.
I would say if you guys can agree on the form of a redaction, it's fine with me. Any of the defendants have a complaint about this?
So is the plan to redact now the charging document from what the
No, the release conditions
Conditions
are.
of release have the charge here. I think Mr. Lee would agree if we just redact that off. Not have an objection to that.
You just redact the charge entirely, right?
Yeah, it's a long line, Judge.
what he's charged with, or whatever. It's already come in at trial multiple times, so I'm not sure what they should.
Well, it's usually come in the form of attempted. I think a robbery in second degree has been said too. But if the error had not been made in the first place, he would have been charged in attempted robbery too, and that was the intent of the prosecutor's office, as I understand it. So we shouldn't, put more and more shade on the circumstances by continuing with something was an error in the first place. So if everybody agrees to that redaction, that sounds like it'll work. Okay. Now, we ready? All right, let's have the jury. Okay, welcome back, everybody. Please be seated. Okay, Mr. Esser, on behalf of Mr. Collins, you're going to call a witness now, is that right?
And the Court Commission, Officer Collins calls Deputy Prosecutor Greer.
Yes, sir. Please come forward to right about here. Raise your right hand to be sworn. So let me swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you very much. Please have a seat right here. Please state your name and please spell your name.
My full name is Gregory Lee Greer, and it's spelled Gregory, last name Greer.
Thank you. Mr. Osler.
Thank you. Good afternoon, Mr. Greer. How are you?
Good.
What do you do for a living?
I am a deputy prosecuting attorney here in Pierce County,
And how long have you been prosecuting?
a little over 30 years.
All right, about to retire?
Very close.
All right, congratulations.
Thank you.
As a deputy prosecuting attorney, is one of your duties to make charging decisions on your files?
Yes.
Can you explain to the jury how that process works, where you get that file from, and then what you do?
Your Honor, objection, Billings.
Foundation, you may proceed.
Generally, information comes to us from law enforcement in the form of police reports. and we review those reports. We make decisions on whether there's sufficient basis based on the information they provide to file charges, and then what charges to bring.
Okay. And when you file charges, is that in the form of what's called an information?
Yes,
All right. And as part of that process, do you also prepare what's called a declaration for determination of probable cause?
yes.
And what's the purpose of that document?
It actually is primarily for the court to determine considerations for release or bail.
All right. And describe for the jury that process. If you file charges, does an individual appear before the court, and what happens at that initial arraignment?
Well, the initial appearance when a person is charged with a crime formally is called an arraignment. So that's when the court puts the defendant on notice of what they're being charged with by the state. So that's a formal procedure, and it's an interaction between the court and the person charged to make sure that that person knows what they're charged with, and some of the details, including the date, the place, some requirements by court rule.
All right. What does the term conditions of release mean?
Well, conditions of release, if we're referring to an arraignment, after the court's notified the person that's being accused of what they're charged with, generally the next step is to determine what conditions that the court will impose on the person in order for them to remain in the community. There's other restrictions that do not have to do with bail and that kind of thing also that are addressed.
All right, we'll talk about that in a minute. Did you have an opportunity, Mr. Greer, to review an incident involving Manuel Ellis from September of 2019?
Yes,
And did you file charges in that case?
I did.
All right, in the manner that you just described?
Yes,
And did you author a declaration for determination of probable cause
I did.
for the purposes we just discussed?
Yes.
All right, and I'm going to hand you, with the court's permission, exhibits 2514 and 2515. Is that okay, Judge?
Yes.
You recognize those exhibits 2514 and 2515?
I do.
What are, start with 2514, what is that?
That's a copy of the information that I filed.
And what date did you file charges against Mr. Ellis?
September 23rd, 2019.
Okay, and then 2515, what's that exhibit?
That is what would have been attached to the information, but it's a separate document here, which is an affidavit of probable cause.
All right, and did you author that as well?
I did.
And was that filed for purposes of the arraignment and the establishment of conditions of release?
And for notice to the defendant of what he's charged with, in this case, he.
All right, and do you know when Mr. Ellis was actually arraigned
I-
on those charges?
I believe he was arraigned the same day.
All right, well, I'm going to hand you, with the court's permission, 2516, and ask if you recognize what this document is. Thank you, Judge.
2516 is an order that in this case, I believe the Commissioner Adams signed, which he works for the judges and handles arraignments, setting the conditions of release in this case.
And would that have been done at the initial arraignment then?
Yes,
And is that a certified copy of the order establishing conditions of release at arraignment for this case that we're talking about?
yes.
Your Honor, I move for admission of 2516.
No objection, subject to the.
Previous discussion.
Previous discussion.
No objection. No objection.
All right. We have to make that one correction, but otherwise 2516 is admitted.
Thank you, Judge. And Mr. Greer, have you seen that document before?
I have.
And does 2516 set out the conditions of release that Commissioner Adams imposed at the arraignment in September of 2019 with respect to Mr. Ellis?
Yes.
And did the court impose a condition that he have law-abiding behavior?
Yes.
What does that mean?
It means, well, it's explained to the defendant, and it means that you're to maintain, to comply with the laws of the state.
And did Commissioner Adams restrict his use or possession of non-prescribed mood-altering drugs?
Yes.
And what does that mean?
That he's not to possess or use non-prescribed drugs.
Like methamphetamine?
Unless he's prescribed methamphetamine, he's not to use it.
All right. And I assume there's some other conditions on there as well,
There are numerous conditions.
and is that standard in any sort of arraignment situation?
Yes.
Okay. And what happens if an individual violates the conditions of release?
Any number of things, actually. Do you want me to expand?
Well, if the state who files the charges gets information that somebody subject to conditions of release violates those, can the state file a motion to have them altered or that he be taken into custody?
It's covered by the court rule, but generally if the prosecutor's office becomes aware that a defendant, a charged person, has violated the conditions, then the prosecutor can go to the court and seek an arrest warrant and lay out the reasons for the request. Or the court can seek a hearing by means of a summons and have the person brought in to address the issue with the court.
In this case, the court set a bail amount for Mr. Ellis. What's the purpose of a bail amount?
Bail is to secure the person's attendance. It gives them some incentive to not flee the jurisdiction or avoid the charge.
All right. And with the court's permission, I'm going to approach with exhibits 2517.
Proceed.
Thank you, Judge. And 2592. Do you recognize those documents?
Yes.
Start with 2517. What's that?
2517 is again an order establishing conditions of release, which is commonly referred to as a conditions of release order. This is one that was, in Mr. Ellis's case, modified about a month after the initial order was entered.
All right. And is that a certified copy of a modification of the conditions of release related to the same case we've been discussing involving Mr. Ellis?
Yes.
There are defense moves for admission of 25 at 17.
Yes.
17, Judge.
No objection, subject to the previous discussion.
No objection.
Objection, Your Honor.
Okay, as with 2516, 2517 is admitted.
Thank you, Judge. Mr. Greer, what's the date on 2517 that the court modified the conditions of release on the incident from September of 2019?
October 21st, 2019.
So about a month later.
Yes.
And sorry, it's a different number. 2592, what's that?
This is a document that is created by, I believe, the court reporter and the judicial assistant that includes the minutes of the proceeding that occurred in this case on October 21st of 2019.
And is that a certified copy of the clerk's minutes related to that motion to modify that we just referenced?
Yes.
Your Honor, I move for admission of 2592.
That's an exhibit the statement received.
You want to take a look at this first?
Sorry.
Please show it to Mr. Liu.
No objection. No objection. No objection, Your Honor.
2592 is admitted.
Mr. Greer again.
Yes.
All right. So 2592 has now been admitted. I think you referenced other clerk's minutes from that motion to modify. Does it indicate what happened at that motion?
It does.
And can you read that into the record for the jury, please?
Verbatim.
Please.
So the body of the document says October 21st, 2019 at 10:32 a.m. This matter comes before the court for a continuance, omnibus hearing, and motion to change conditions of release. DPA Tyler Kennedy, present for the state. Attorney D. Sontag, present for the defendant who is in custody. DPA Kennedy addresses the court regarding the matter. Then at 10:32 a.m., there's a notation. Attorney Sontag addresses the court and requests a PR release so defendant can seek treatment. 10:33 a.m., DPA Kennedy, note no objection from the state so defendant can seek treatment. 10:33 a.m., court grants the change in conditions of release. Court grants the continuance.
All right, and you read into the record PR. What's PR?
Personal recognizance.
Okay. And that means lowering of bail to no bail so that you can get out of custody, right?
Correct, means releasing the person.
And so the state didn't oppose Mr. Ellis being released for treatment purposes?
Correct.
Okay. And then what's been admitted is I'll take that from Mr. Greer. This one, 2517, is that the order establishing conditions modified as you just read from the other exhibit?
Yes.
So in that modification, it indicates that he meaning referring to Mr. Ellis, was being released pursuant to the jail transitional service plan. What is that?
I believe, well, I know it's a program that's set up by the court, prosecution, defense attorneys, and the community. And so pretrial services is the body that, with defense assistance, screens a person to see if they qualify for the services that are offered. And if they do, then they can set a hearing, which is what happened here, in front of the Superior Court judge, which was Judge Johnson, I think, in this case, to ask the court to release, in this case, Mr. Ellis, so that he can take advantage of the program.
All right. Is that through Pierce County Alliance, do you know?
It's through Greater Lakes Mental Health and Pierce County Alliance.
Okay. All right, and so it sounds like that Judge Johnson agreed to allow Mr. Ellis out of custody, remove the bail requirement so long as he complied with those conditions that are outlined in that document.
Right. There's a separate document that includes particulars that Judge Johnson would have relied on, such as where he's going to reside and who he's going to reside with, and then the particulars as to the agencies that he's to report to, those kinds of things. But this, once that's understood, probably on the record with the defendant, then it's shorthand put here that the defendant has to comply with those conditions.
All right, and has the defendant provided a copy of that upon the conclusion of the hearing?
At the hearing, yes.
Okay. And like we discussed with the conditions set at the initial arraignment, if Mr. Ellis were to violate those conditions, would the court have the same ability to modify again or take him into custody?
Right. The court has discretion if there's an allegation and even a proven situation where a person has violated the conditions to modify, including to put the person into custody, any number of different.
And does the modification of conditions of release have the same requirements that he not possess or consume non-prescribed and altering drugs?
Yes, everything that was imposed before, other than the bail situation, reduced to personal recognizance, and then the requirement that he participate in the treatment programs.
Okay. I'm going to, with the court's permission, ask you about one more document. That's Defense Exhibit 2590.
Proceed.
I'm just showing counsel.
Sure. Yes.
Mr. Greer, you referenced in the clerk's minutes that hearing also had a motion to continue. Do you recognize the exhibit? And can you tell me the exhibit number again for the record?
2591.
All right, do you recognize that?
I do.
What is that exhibit?
This is a scheduling order.
All right, and was that executed on the same date as the motion to modify and the motion to continue?
This actually is dated October 7th of 2019.
And when somebody's arraigned on criminal charges, are they given what's called a trial date?
They are.
Okay. And does that document, I guess, is it a certified copy of a scheduling order assigning a trial date to Mr. Ellis's 2019 case that he charged?
Yes.
All right. Here I move for admission of, is it 2519?
2591.
2591, Judge.
Objection, Your Honor.
Can I say this again, Mr. Gordon?
Judge, it establishes a trial date that was still outstanding at the time of his death, so it's relevant to the fact that these were still pending charges.
Well, this trial date is pre his death. Take a look at it.
Well, I don't think I need to, do you know that Mr. Ellis's trial was still pending on the 2019 case when he passed away in March of 2020?
It was.
Okay, thank you, Judge, that's all.
All right, so it's to 2591, you're withdrawing the?
Judge, yes.
Okay. Mr. Lowe.
Thank you. Mr. Greer, good afternoon.
Good afternoon.
Mr. Greer, you explained the process of a violation of the conditions of release. Is that correct?
Generally, yes.
Okay. And you indicated that there's discretion by the court what to do in the event of a violation?
Correct.
Okay. The court could modify conditions of release or incarcerate someone. Is that correct?
Any number of things given the allegations, the nature of the case, but the court has broad discretion to do what it thinks best.
Okay. So just because there's a violation doesn't mean someone will be automatically incarcerated for a violation. Is that correct?
Correct.
And just to be clear, after you prepared the affidavit of probable cause, you had nothing else to do with this case?
I made a recommendation as far as what our office's position would be, as to what bail should be set and other conditions at the time the defendants were arrested, but I didn't handle the arraignment. We have somebody that handles all the people every day that are arraigned.
Understood. And someone else, another DPA was assigned to the case?
Yes.
Okay. Thank you, Mr. Greer. I have no further questions on it. You know, taking any questions?
Very briefly. So, you reviewed the court records in this case, is that right?
I did.
Okay, and so it indicates that he has an initial arraignment on September 22nd,
23rd, I think.
sorry, 23rd, 2019.
Yes.
And at that initial arraignment, the court found probable cause and set conditions of release.
Correct.
Okay. And then he appears before the court about a month later, is that right, in October?
October 21st, I think.
Okay, and that's for an in-custody hearing to modify the conditions of release, is that right?
Yes.
Okay, and then at that point, there was a motion made to modify the conditions of release and release Mr. Ellis on personal recognizance,
Correct.
amongst other things.
With conditions, yes.
With conditions. And one of those conditions continued to be that he have law-abiding behavior
True.
and that he not consume any unprescribed drugs.
Yes.
And another condition was as well that he not, well, I don't know actually what the exact verbiage is, but that he not commingle with known drug dealers or something like that as well, right?
I'd have to look at the document again. It's generally a pre-printed condition that's checked in the same area as the don't use non-prescribed drugs.
Okay.
I handed it to Susan.
I think it says knowingly associate with any known drug users or sellers, right?
If you're looking at the exhibit and it's checked, then yes,
Except in treatment.
except in treatment.
Okay, so he appears in October before the court again, and the court grants that motion and releases him, correct?
Yes,
Pursuant to those conditions.
yes,
And then you reviewed the records, and there's another hearing, a scheduling hearing or a status conference, correct?
yes, there would have been a status conference, yes.
And at that point, the court entered, I believe it was in what's called an omnibus order, is that right?
It's a separate order, yes, an omnibus hearing
Which set
order.
a number of other court dates, including a trial date, right?
The OH may reference it, but the OH is just a document that tells the court, after the parties fill out the OH order without the court's involvement. And it just discusses various things that may come up in the proceedings yet to come, and then that's presented to the court.
Okay. And on March,
But specifically, the trial date is established by a separate scheduling order, not by the omnibus order.
correct, so then there's a scheduling order entered as well, which has a trial date.
Well, if the initial trial date is set at arraignment, if the trial gets moved, there's what's called an order continuing trial, which is different than the scheduling order.
Okay.
But the scheduling orders will always have the dates that are set at that point. And I don't want to get too involved here, but it'll have for instance, the order that was shown to me, the scheduling order, had the existing trial date on it at the time.
Okay.
And it had other dates also of intervening dates.
Can we have these marked as 2591? Is it?
Why don't you show that to me?
It was or was not?
This is not 2591. I can tell you that much.
Yes, please.
2593.
Okay. So showing opposing counsel was remarked as 2593. Is the order continuing trial? Handing you what's remarked as defense exhibit 2593. Are you familiar with that document?
Yes,
Okay. And what is it?
this is the order continuing the trial date.
Okay, that's a certified court record as well.
It is.
On the move for admission of 2593.
Any objection?
No objection. No objection.
Okay, and
Hold
2593.
hold on a second, I'm still here.
Oh, sorry.
Exhibit 2593 is admitted.
Thank you, Your Honor.
Go ahead.
And so 2593, what's the next court date that's indicated on that?
Well, this order was signed on February 10th, and it set two dates. It set a trial readiness or status hearing for March 13th of 2020, and it continued the trial to April 1st of 2020.
Okay, so Mr. Ellis had an upcoming court date on March 13th, 2020, right?
Correct.
And he had a trial date coming up in April 1st,
Yes,
2020.
yes.
And so the conditions of release that the court set were still in place on March 3rd, 2020, correct?
Right. They would have stayed in place until the court modified them or the case was disposed of and the court took action then.
Okay, thank you.
Nothing more.
Okay. So, Mr. Greer, you're excused. Thank you.
Thank you, Your Honor.
If I don't see you, enjoy your retirement.
Thank you.
Next witness. This is by you, Mr. Conrad?
Yes, Your Honor.
Okay, on behalf of Defendant Rankine?
Officer ranking calls Laura Fonda.
Yes, please come forward right about here and raise your right hand to be sworn.
Here.
There you go. Solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you very much. Please have a seat right here. Please state your name and please spell your name.
Laura Fonda, Laura Fonda.
Good afternoon, Ms. Fonda. Did you formerly go by, your last name was Van Horn, is that right?
Yeah, that was my maiden name.
Okay. And, Ms. Fonda, what do you do for a living?
I'm a substance use disorder professional,
And where do you work?
Pierce County Alliance.
And how long have you been in that role?
I have worked for Pierce County Alliance for about 4 years, and I've worked in treatment for about 6.
Okay. And can you talk to us a bit about what your job responsibilities are as a substance use counselor?
Yeah, so currently I manage the assessment team and then also the medications for opioid use disorder program that we have in the jail.
Okay.
But at the time I did assessments full-time,
Okay. At the time, in
2019,
okay.
yeah,
So you did an intake assessment in November of 2019.
correct.
And have you had an opportunity to review some of the records associated with that?
I have.
And who was the person that what was the client's name?
Manny Ellis.
Okay. And I'm going to hand you what's been marked as State's Exhibit 984.
984.
Yes, Your Honor.
Thank you.
And I want to ask you a couple of questions about it, Ms. Fonda.
Mm-hmm.
So, in the course of your duties as an intake assessment, well, let me ask you, what are your duties as an assessor?
So there's 2 primary tasks in the assessment. One is to determine if they are diagnosed with any substance use disorders, and then the other one is to determine the recommended level of treatment, as well as identify any specific treatment needs that they have.
And do you routinely take notes or document information that's given to you by patients?
Just in everything that's documented is in the actual assessment.
And what type of information do you write down?
We look at their substance use history, any signs or symptoms of intoxication or withdrawal, medical issues that might need to be addressed, mental health, behavioral issues that might complicate treatment, their willingness and their desire to change, what level they're in as far as that, relapse or continued use potential, and then also their environment.
Okay. And why is it important to document some of that information?
We always say if it's not documented, it didn't happen.
Okay.
So just to have a
And
record.
Are these records kept in the normal course of business for Pierce County Alliance?
Yes.
And are they relied upon by yourself or other professionals at Pierce County Alliance?
Yes.
And the records that you have in State's Exhibit 984, does that contain your assessment in this?
Yes.
And was the assessment made at or near the time of the actual assessment that took place?
Yeah, it would have been, well, I can tell you exactly. So the assessment itself is done as we go. The write-up summary is generally done after, usually the same day.
Okay, so you're actually taking notes while you're meeting with the
Correct,
client?
yes.
So I want to ask you about the assessment that took place on November 14th, 2019. And how, does it indicate how long that assessment was?
Yeah, there is a billing note in here. I believe it was 2 hours and 45 minutes, if I'm not mistaken.
Okay, so you met with Mr. Ellis for about 2 hours and 45 minutes, and you're reviewing, you indicated his substance abuse history, mental health history, amongst other things. And do you have access to other records as well that you can rely upon in creating this assessment?
Not generally, unless the client brings them in or it's required by the court for some reason. But in this case, it was all what Manny self-reported.
Okay. And so I want to ask you about some of the things that you wrote down within those notes. On the first page, paragraph 3, what are some of the prior diagnoses that Manny relayed to you?
He reported he'd been diagnosed with bipolar type 2, depression, schizoaffective disorder, PTSD, and ADHD.
Okay. And did he indicate whether he was on any type of medication?
Yeah, he said he'd been on Seroquel for about 2 weeks.
And the record also indicates, I want to ask you about what the record indicates about the Seroquel and how he describes the medication. Actually, if you could read the note there that you took, starting with he describes the medication.
He describes the medication as mildly effective, as evidenced by his statement, "I still hear voices, but they're quieter."
Okay, so what is that indicating to you about how the medication is working?
I'm not a mental health expert, but 2 weeks is fairly early. A lot of times people don't have their symptoms completely resolved from medications, and a lot of times it takes a while and there's some adjustments that need to be done.
And what were some of the symptoms that were associated with his mental health issues?
Mainly he reported that he heard voices, but it was something that he felt he was able to cope with.
Okay. And if you could keep reading on within your assessment, starting with key reports.
He reports that he started hearing voices in early adulthood. Clients report substance use, including methamphetamine and cannabis, exacerbate his mental health issues, and that a recent 5-day binge on methamphetamine led to a, quote, full psychosis, which resulted in him being arrested and later, or being assaulted and later arrested.
Okay. And so during your assessment, what was your determination, if any, about how methamphetamine affected Mr. Ellis's mental health issues?
I believed that it put him at higher risk for relapse, and also that he would be more likely to have severe symptoms earlier in a relapse than somebody that didn't have mental health issues.
Okay. And what did Mr. Ellis tell you about how his substance use led to being assaulted and arrested?
He had said that he was at, I believe, the KFC, and he wanted to order a beverage, but they wouldn't help him, so he said that he reached across the counter to get a cup and put money down, and then he was assaulted.
Okay. And if you turn to page 2, I want to ask you to read the second paragraph there about client reports,
The legal history part?
please.
Client reports a history of legal issues related to substance use, the most recent of which was a 9/22/19 arrest resulting in pending robbery 2 charge, at which time the client was under the influence, which he states exacerbated his existing mental health issues.
And what did Mr. Ellis tell you about his substance use history?
He reported that he'd been using meth regularly since he was 24.
I'm going to ask you on the next page, ends in page 799, under drug history, what you wrote down. Sorry, it should be the next. I can point out to you, Ms.
Let's see, where are we at? Okay. Methamphetamine use since he was 18, regular use since age 24, denied having a tolerance or withdrawal issues, peak use 0.5 grams per day. Cannabis use since age 13, regular use since age 17. On 2/28/20, it is noted that he has not used methamphetamine and marijuana since 12/26/19.
It indicates that there were drug screens that were taken of him as well in November, December, and they were all negative.
Correct.
One of the things that I noted was that this is signed by yourself as well as Mr. Ellis, is that right?
Yes.
And does Mr. Ellis have an opportunity to review this as well prior to signing?
Yes. I mean, he would have the opportunity to, but most people don't.
Okay. And one of the other things I want to ask you about is under chemical use and abuse history within the assessment.
Mhm.
It's on the bottom right-hand corner, it should say WAAG, and it's 678.
Okay.
And attempts at stopping using. What did Mr. Ellis indicate to you about trying to stop?
He said, I've tried 6 or 7 times, every time I ran out.
And if you keep flipping in the assessment to page 680, reasons for reported use is another section there.
Mm-hmm.
Is that something that you fill out or that Mr. Ellis fills out?
I asked the questions and he would respond with a list of options, never, rarely, sometimes, often, or almost always.
Okay, and so you're asking him questions about the reasons for his reported use?
Correct.
And one of the things that he indicates there, well, can you go through the reasons for reported use or why he uses?
Do you want me to include his answers?
Yes, please.
Physical pain, never. Feel sick, never. Bored or lonely, sometimes. Sad or depressed, almost always. Mad or angry, sometimes. Scared or afraid, sometimes. Happy or excited, often. To increase energy or alertness, often. To find new excitement, almost always. Increase social confidence and courage, almost always. Act like other people, almost always. Have fun and party with friends, almost always. Forget or escape problems, almost always. Relax from pressure or stress, often. Being in a certain place or situation, almost always. Pressures from other to use with them, never. Having problems you feel you can't solve, rarely. Drugs being easy to get, often. And the need to feel high, almost always.
And then the next page, 682, is a summary assessment. Is that your summary of your assessment that you've done there?
Yeah.
And the second paragraph down, starting with client reports, if you could read that whole sentence for us as well, please.
The client reports a legal history of legal issues, that one? Or?
Yes, please.
Client reports a history of legal issues related to substance use, the most recent of which was a 9/22/19 arrest resulting in pending robbery 2 charge, at which time the client was under the influence, which he states exacerbated his existing mental health issues.
Did Manny ever explain to you why he took his clothes off during the A&W incident?
He said that he didn't know. He didn't remember doing it.
Did he ever indicate to you how much drugs it would take to affect his mental health issues?
He didn't. He just said that he'd been using about a half gram a day. I'm sorry, that was at his peak, at peak use, so
Okay.
I'm not sure how much he was using at the time.
Okay. I don't have any further questions, thank you.
Cross-examination.
Thank you. Good afternoon, Ms. Fonda. Go back to page 682. Counsel just had you read one sentence that I think you read on another page. If you could just finish reading what you wrote in that section, please.
He reports a history of multiple treatment attempts, the most recent of which was successful completion of inpatient at CMAR, which client reports was motivated by internal desire to change. Client reports internal and external motivation to seek treatment and change his use to address his legal issues as well as to improve overall mental health. Client expresses a willingness to participate in treatment planning and to attend all scheduled activities, including mental health treatment and sober support meetings, both of which he states he is already engaged in. Client is in need of scheduled contact and motivational strategies to address potential ambivalence and strengthen motivation.
Ms. Fonda, do you remember Mr. Ellis?
Yes.
And what do you remember about him?
I remember,
It's a little vague.
How well do you remember?
better than I remember most clients that I meet with.
And why is that?
He seemed really open and honest and that he genuinely wanted to change.
And how many clients do you typically see a day for an assessment?
At the time, I was seeing about 3 a day.
It's fair to say Mr. Ellis stuck out? to
Yes.
you? Do you also remember you were asked about his clothing, or excuse me, what he said about removing his clothing? Do you recall whether you had a discussion with him about what he thought caused that?
I do.
And what did he tell you?
He said that he didn't remember doing it, but that looking back, he felt that it was God telling him to do that and that it might have saved his life and kept him from getting killed by the police.
And in terms of Mr. Ellis, it sounds like you did an assessment on him. Do you recall whether or not Mr. Ellis was court-ordered to attend
He was,
Pierce County Alliance?
he was not.
He was not?
Correct.
Okay. And so he was there voluntarily, is that right?
Yes.
Yes? Okay. And your assessment of him, did you have an assessment of him about whether or not he was committed to trying to overcome his drug addiction?
Yes. And I believe that he was, yes.
And is it unusual in your line of work to have people who relapse and who make multiple attempts at overcoming drug addiction? It's relevant given the issues that they've raised, Your Honor.
I think this is marginal, but I'll let you do it. Overruled.
Is it unusual in your experience to have people make multiple attempts?
No, I would say it's the norm.
And how did you assess Mr. Ellis in terms of what level of care he needed?
I put him at level 1.0 outpatient, which consists of less than 9 hours of treatment services per week, which is the lowest level of care that we offer.
And why did you assess him as the lowest level of care?
Because he expressed internal desire to change. He was there because he wanted to change. He was willing to engage in mental health and had already started. He was very involved in church and sober support meetings, and a lot of times if people are already doing that, we don't want to overwhelm them with treatment because then they'll stop doing those things that they already have in place, which are natural supports. And then also, he seemed to have a very stable living environment with his sister, who was very supportive.
And I think you talked about, or you were asked questions about Mr. Ellis seeking other kinds of treatment. Did he have, do your notes indicate whether or not he was getting mental health treatment?
He did report that he had recently gone back to Greater Lakes.
And he was taking medication, is that right?
Correct.
And is it correct that that medication he was taking was for his bipolar and schizoaffective disorder conditions?
That's what he reported to me, yes.
And he indicated he was taking those medications?
Correct. He indicated that he felt it was essential to his recovery to stay on medications.
And you were also asked some questions about, I believe it's page that ends in 678, about his attempts at stop using. Do you recall that?
Mm-hmm.
Can you just read, what's the next section there?
Cannabis, is that what you're referring to?
No, I'm
Or-
sorry, right under attempts at stop using, under methamphetamine.
Oh, attempts at controlling use?
And what did Mr. Ellis tell you? What did you report there?
Can I see it?
Mm-hmm.
Overall, you may answer.
What did Mr. Ellis indicate on the attempts at controlling use?
He said, I thought maybe I can just do it sometimes. That's how it starts.
That he could just do it sometimes?
Mhm.
That's how it started, when he relapsed?
Correct.
And you were asked questions about ways that urinalysis that Mr. Ellis had. Is it correct that the last he had a urinalysis at Pierce County Alliance was in December of 2019?
That's correct.
He hadn't taken any since that time, is that correct?
That's correct.
And you've interacted with people, many people who've been addicted to methamphetamine, is that right?
Correct.
And in your experience, there are high-functioning meth addicts?
Yes.
And have you seen people,
I'll sustain this objection.
you've seen people who are high on methamphetamine?
Many times.
And you would agree there's a wide spectrum of behaviors from people?
I think this may be beyond her expertise, frankly.
Well, I can flesh it out a little bit more. In your experience, have you seen people on methamphetamine?
Yes.
Okay, and you've actually had people in your office who have used methamphetamine, is that correct?
Yes.
And they've actually been high at the time you've seen them?
Correct.
And in your experience, there's a wide spectrum of behavior among people who use methamphetamine, correct?
Yes.
And in your experience, it's not very often that meth users become aggressive, correct?
Sustained.
Do you have experience in terms of seeing people on methamphetamine?
Yes, I would estimate I've seen,
Sustained, the objection is sustained.
And you were aware, when you've seen people on methamphetamine, have you seen people who get quiet and overly focused?
This sustained, this is,
Were you aware that Mr. Ellis was diagnosed with ADHD?
yes, that's what he reported to me.
And have you seen other people who are addicted to methamphetamine who have been diagnosed with ADHD?
are we going to get into the reasons why Mr. Ellis was addicted?
I'm just asking her whether or not she's seen people. I asked whether or not she's seen people who have been addicted to methamphetamine who have also
Right.
been ADHD.
And she reported this already. She affirmed it, said she found that he had an addiction. That other people are also addicted, I don't see what that's got to do with anything.
How many times did you see Mr. Ellis at PCA that you can recall, other than the time you did the assessment on him?
At least a handful of times.
And did you have contact with him when you'd see him?
Maybe just to say hi and nice to see you.
And do you know was he at PCA for group meetings and for individual sessions with the therapist?
Yes.
And are all of those occasions where he was there and statements that he made also documented in these records?
Yes.
Not that you were asked about them, but they're documented in there, is that correct?
Correct.
Okay, and who are the other people who saw Mr. Ellis on a regular basis?
Sustain the objection.
I can have just a moment. That's all I have. Thank you, Ms. Fonda.
Hold on a second.
No, I don't have.
Ms. Pritchard? Any redirect? continue.
Fonda, do you remember meeting with the Attorney General's office in September of this year?
I do.
Okay. And have you had an opportunity to review the notes from that interview?
Yes.
Okay. And one of the things that's indicated in that note from the Attorney General's office is that you told them that when Manny took drugs, it didn't take much to affect his mental health and make him confused. Do you remember stating that?
Yes.
Okay, so is that true?
Yes.
No further questions.
Ms. Heeks?
No questions, thank you.
Nothing will take you.
Yeah, thank you. Okay. Ms. Fonda, you're excused. Thank you very much. And you can leave all that stuff there. Okay, ladies and gentlemen, it's a little after 4 o'clock, so we'll take our recess for the day. Please do not discuss case among yourselves with anyone else. Do not permit anyone to discuss case with you in your presence, and please avoid any reports on the media, social media, or otherwise on the subject of this trial.